To talk about responding to office actions. And there's a common conception that when you respond to an office action, it's a problem. The examiner gave you some prior art and you have to solve it and get a claim, get a good claim, and so on. But I think it is much more useful to look at the act of responding to the office action as a performance. And let me explain why. It can be very complicated to respond to an office action. And a lot of the complication is hiding. And if you look at the office action as a puzzle, you absolutely will solve it. I mean, we're all intelligent people. But just because you solved the puzzle that the examiner gave you doesn't actually mean that you've done what the client needs or what you wanted to do in a more strategic sense. So what it tells us that there's some sort of intent behind your response to the office action. And I think you should look at the responding mainly as a performance. We're performing because people are watching us and we're trying to have an effect on them, emotional and rational. And it is also an opportunity. It's not just we got to solve a puzzle and we solved it. It's an opportunity to do something. And I believe that if you treat the response as a performance and as an opportunity, it helps you frame the problem or perhaps situation that you have and helps you focus your efforts in figuring out how to, yes, solve the office action. So I'm going to give you some questions. The order of answering the questions is up to you, whatever's easier. But I believe that answering the questions will help you figure out what your goals are and how you should be performing. So first, who are we performing for? The client, yes, he's watching us. The examiner's supervisor, or perhaps examining division. A competitor who might be watching the prosecution in the case. And later on down the road, due diligence for an investor, court, perhaps an infringer looking at the file wrapper, deciding what they should be doing. So the question to you as patent attorney is, what do you want to show these people? So if we think about the examiner, we want to convince them of something. Now, yeah, we want to convince them that we overcame the art. But maybe we want to do a little bit more than convince them that we overcame the art. Because if you think about it, at least legally, at least in the US, an office action is the examiner telling you you haven't reached the burden of proof that you don't not deserve a patent. I hope I haven't gotten confused here. In other words, you deserve a patent unless the examiner can say, well, maybe you don't. And then you tell the examiner, well, you haven't shown that maybe I don't. It's not exactly proving that you deserve a patent because you can't prove the lack of prior art. So when we want to convince the examiner, well, how does the examiner see the situation? We might want to change it. How does the examiner understand the invention? Does he believe in the invention? We might want to change that. Is the examiner being helpful? Well, we definitely want to change that. Is the examiner acting square? You can insert some other language instead if you want, but often it happens because you're not helping the examiner. I want the examiner to be helpful. I want to help him as well, or her. The client. Often clients don't know what your patent is for or about. When you respond to an office action, it helps your client understand what this patent is going to do. And of course, super important, the client always has to wonder if the patent attorney, you, knows what they're doing. When they watch you respond to an office action, when they watch the response, it can be a data point regarding your abilities. And if we think about all the other watches I mentioned, often you want to show that you have a great invention, or at least that you're professional in what you're doing. And why is that important? That maybe they should work with your client. Maybe they should run away from your client and not compete. And usually you want to convince them that they can't get the benefit of the invention without infringing the patent that you're expected to get. So the way that you respond to the office action is a performance which is supposed to convince them of that. Few more questions. What do you have in hand? Well, first of all, there's resources and there's constraints. What does the client need is a super important constraint. Budget constraints and timeline constraints, both for now, for this response, and for what will happen later in the prosecution. What happened in other countries and in other files, and what will happen in other countries and other files, is a super important constraint. What it is that you can prove or convince, that's a constraint. Maybe you have data, maybe you don't, maybe you can obtain it. What is actually written in the specification? A lot of countries have very strict requirements on added subject matter, intermediate generalizations, cherry picking. I could continue. What other art are you aware of, whether or not it was raised in this case? Some countries have legal and process requirements, what you can get a patent on, what you can actually say, can you narrow the patent, can you broaden the patent? Each country with its own special laws. Goals. Okay, I started off by saying we want to be goal-oriented. So sometimes you know ahead of time what your goal is, but sometimes you create a new goal or you discover a goal as you're handling the office action. Okay, so if you're just doing it as a puzzle, you're done. But if you treat it as a performance, and we'll talk about it in a minute, you could change. So goals could be for the patent, for the product which the patent covers, for competitors, for licensees, or in general for other tactical or strategic goals of your IP portfolio as defined by what the company has as tactical and strategic goals. Last but not least, the office action is something, and it has in it important information which relates to your performance. There's art, and maybe there's clarity or support or enablement issues. There's how the examiner understands the art. As I noted, your performance has to do with convincing the examiners that they misunderstood the art. There's the rejection. That's usually the heart of the puzzle. How do I overcome the rejection? There might be some indication that they're willing to give you this patentable subject matter, allowable subject matter. The examiner might tell you, oh, I might be open to giving you claim 14. And maybe there's trouble in the office action, which is brewing for later. Perhaps the examiner is not aware of it. They gave you an A-type reference, but when you read it, you understand that that A-type reference is actually an X-type reference. The entire process is not a one-shot process. And I don't just mean that you will often have another office action. What I mean is that the act of doing the response, and that's why performing is so important, can help you grow. I don't just mean as a patent attorney, I mean the invention itself. You might realize that it's more than what you thought it was. And you might help you focus on what is important about the invention or what is inventive about the invention. So one of the things that happens is that you have a process where you talk to the client and you can learn about what the client's doing, about what the client understands now, not 5 years ago when you wrote the patent application. So you should expect iterations during the preparation of the response. And with any luck, these iterations will actually trigger something happening with the client. The client will say, oh, wait a minute, now that I see the rejection, I, not you, client, understands his invention better. Suddenly he understands, she understands what they can do with this piece of technology that they had. Lastly, this whole process of getting an office action is an opportunity. In a trivial sense, you file a patent application and you sit and wait, like in the waiting room. Suddenly, there's somebody to talk to. The examiner is talking to you. You have an opportunity to learn about the prior art and about the competitors who might be cited against you. And I don't know if to say if you're lucky or not lucky, the examiner will probably bring their own way of searching and looking at the art that you yourself did not. It gives you an excuse to talk to the client. Before I said you should talk to them, but you need an excuse. It gives you an opportunity to change the claims to what the client actually needs, or an opportunity to learn what you can actually get with this patent. It's an opportunity to refine the strategy of the patent portfolio. And in order to do this, what you need to do is take the initiative. So as long as you look at it as the examiner gave me a puzzle, I'm going to solve it, you don't have the initiative, the examiner does. If you look at it as here's an opportunity, the examiner's talking to me, the examiner said some stuff, let's see what I can do with it, now you have the initiative. You might ask yourself, why do I feel, Meir, that this whole issue is ignored both when training patent attorneys and when patent attorneys do their work? At least I believe that most patent attorneys look at office actions as puzzles that need to be dealt with. I think the biggest reason is what I call the explicit-implicit bias. You have a document, and the entire document is a puzzle. They cited prior art, they said they're not going to give you a claim. That's explicit. What does the client need, and should we change our claims according to what the client now knows might be important in 4 years? That's implicit, it's not written anywhere. When you turn the process into a performance, it forces you to think about these implicit sides. During training, when you train a patent attorney trainee, it is much, much easier to give them feedback on the puzzle part. Oh, the way you worded your argument isn't good. They wrote the argument, and you can say it's not good. Oh, the way you read the prior art and discovered that it doesn't actually mean what the examiner said, that is very good. Okay? It's easy feedback to give. Another reason is, usually during training people, they get their goals from a supervisor, like myself. And the supervisor deals with the goals implicitly. They know what the client wants and where the client wants to go, and they're going to talk to the client, and it can all fly right over the head of the trainee. And because it's all done implicitly, it is much more difficult for the supervisor to express all of these needs. But now that I made this presentation, you're aware of all of it, so no excuses left. And please, next response, make it a great performance. Thank you.